Lesson: Financial Privacy, FACTA, and Dodd-Frank Act. The financial privacy landscape in the United States is governed by a complex framework of laws designed to protect consumer information while allowing for the necessary flow of data within the financial industry. Among the most significant federal laws in this domain are the Gramm-Leach-Bliley Act, the Fair Credit Reporting Act, the Fair and Accurate Credit Transactions Act, and the Dodd-Frank Wall Street Reform and Consumer Protection Act. Each of these laws addresses different aspects of financial privacy and security, providing actionable insights and practical tools for professionals aiming to ensure compliance and enhance consumer trust. Small. The Gramm-Leach-Bliley Act, enacted in 1999, primarily addresses the management of nonpublic personal information by financial institutions. One of the pivotal components of GLBA is the Financial Privacy Rule, which requires financial institutions to provide customers with privacy notices that explain their information sharing practices. This rule mandates that institutions offer consumers an opt-out option if they prefer not to have their information shared with non-affiliated third parties. Professionals can implement this requirement by developing clear and concise privacy notices and establishing user-friendly opt-out mechanisms. For instance, a bank might employ online portals or mobile app interfaces to facilitate customer preferences regarding data sharing. Another critical element of GLBA is the Safeguards Rule, which obliges financial institutions to develop, implement, and maintain a comprehensive information security program to protect customer information. This involves assessing risks in each relevant area of the company's operations and designing a safeguards program tailored to these risks. A practical tool for this is conducting regular risk assessments and employing encryption technologies to secure sensitive data, both in transit and at rest. By integrating these measures, financial institutions can better protect against data breaches and unauthorized access. Turning to the Fair Credit Reporting Act, this law, enacted in 1970, regulates the collection, dissemination, and use of consumer information, including consumer credit information. One of the FCRA's core objectives is to ensure accuracy and fairness in credit reporting. To comply with FCRA, organizations must implement procedures to verify the accuracy of the information they report to credit bureaus. Companies can utilize automated systems to regularly cross-check data for errors and discrepancies, fostering higher data accuracy and consumer trust. Additionally, FCRA mandates that consumers have the right to access their credit reports and dispute incorrect information. Financial professionals should facilitate these processes by providing clear instructions on how consumers can obtain and dispute their credit reports. The Fair and Accurate Credit Transactions Act, an amendment to FCRA passed in 2003, introduced further consumer protections focusing on reducing identity theft. FACTA requires businesses to take appropriate measures to dispose of consumer information securely. This can be achieved by implementing document shredding policies and using software to permanently erase electronic data. Furthermore, FACTA mandates the Red Flags Rule, which requires financial institutions and creditors to develop and implement identity theft prevention programs. These programs must identify, detect, and respond to patterns that could indicate identity theft. To address this, companies can use machine learning algorithms to detect anomalies in transaction patterns, which may signal fraudulent activities, thereby enhancing their identity theft prevention strategies. The Dodd-Frank Wall Street Reform and Consumer Protection Act, enacted in 2010, introduced comprehensive changes to financial regulation, including aspects of consumer protection. One of its notable creations is the Consumer Financial Protection Bureau, which oversees the enforcement of federal consumer financial laws, including those related to privacy. The CFPB provides a framework for addressing consumer complaints and ensuring fair treatment in financial services. Professionals can leverage the CFPB's tools and resources, such as the Consumer Complaint Database, to identify and rectify systemic issues within their organizations, thereby improving customer satisfaction and compliance. A real-world application of these laws can be seen in the case of Equifax, one of the largest credit reporting agencies, which suffered a significant data breach in 2017. This breach exposed the personal information of approximately 147 million consumers, highlighting the critical importance of robust data security measures and compliance with privacy regulations. In response, Equifax implemented a series of reforms, including enhancing their encryption protocols and improving their incident response strategies. This case underscores the necessity for financial institutions to maintain vigilance and adapt their privacy practices to mitigate risks effectively. In practice, adopting a privacy-by-design approach can significantly enhance compliance with financial privacy laws. This framework involves integrating privacy considerations into every stage of product development and organizational processes. For instance, during the design phase of a new financial product, companies should conduct privacy impact assessments to identify potential risks and incorporate privacy-enhancing technologies, such as data anonymization or pseudonymization, to protect consumer information. By proactively addressing privacy concerns, organizations can reduce their exposure to legal liabilities and strengthen consumer trust. Moreover, ongoing employee training and awareness programs are essential for maintaining compliance with financial privacy laws. Employees should be regularly educated on the latest regulatory requirements and best practices for data protection. Interactive workshops, e-learning modules, and simulated phishing exercises can equip staff with the necessary skills to recognize and respond to potential privacy threats. By fostering a culture of privacy awareness, organizations can minimize the risk of human error, which is often a significant factor in data breaches. In conclusion, navigating the complexities of financial privacy laws in the U.S. requires a multifaceted approach that combines legal compliance with practical tools and frameworks. The GLBA, FCRA, FACTA, and Dodd-Frank Act each offer unique provisions that, when effectively implemented, can protect consumer information and enhance organizational trust. By leveraging privacy notices, risk assessments, automated systems, identity theft prevention programs, and privacy-by-design principles, financial professionals can address real-world challenges and elevate their proficiency in safeguarding consumer privacy. As the financial landscape continues to evolve, staying informed and adaptable will be key to maintaining compliance and ensuring the protection of consumer data.